Law of Torts, most important questions and tips. Dear student friends, today I wish to take up in English media Law of Torts from first semester, most important questions and tips to enlighten you to face the exam successfully. I once again let you know, dear student friends, in the heading that is caption, the subject name in Telugu is there. That particular video is in Telugu language only. Whether in English is mentioned or not, all the videos are in English language only. Basically, I started all lectures in delivered all lectures in English only. After completing nearly 150 lectures, I started uploading in Telugu language also for the benefit of our Telugu students in the states of Andhra Pradesh and Telangana. But even after starting in Telugu language, when I started teaching them in Telugu with good improvement and with latest developments from internet, I also started uploading the same lecture in English language. So you need not have any confusion about my lectures. You see the caption that is heading. If the word in Telugu is there, it is in Telugu language. If the word in Telugu is not there, it is deemed to be in English language only, because I cannot speak fluently in any other language, Hindi or extra. So in Telugu is there, that video is in Telugu, and if it is not there, that video is in English only. Today, I wish to let you know the most important questions on law thoughts from examination point of view, and also will give you some tips how to face the question, and what questions are to be selected first for preparation in first phase, what questions are to be selected from examination point of view in second phase, third phase, and remaining in the fourth phase. Because the standard of student, competence of students varies from person to person, institution to institution. For some students, 100 pages book also is more. For some student, 1000 pages book also is very small. So it depends upon the standards. Wherever you study in an institution where you don't find good number of infrastructure, and in national law schools and other prestigious institutions where you find wonderful infrastructure, the degree will remain same, and both degrees are eligible to get enrolled in bar council to start your career as an advocate. So now it is for you to prove your competence and ability in legal profession by doing hard work. Now, dear friends, let me tell you, this law of torts is prescribed for study as compulsory paper not only for 3-year LLB course student, but also 5-year LLB integrated course. Actually, normally in most of the universities, all last of subjects for 5-year course start in third year of 5-year LLB, and all law subjects start from first year of 3-year LLB. However, there are some universities, the students are the universities provided an opportunity to the centers of legal education to prescribe some law subjects in first year pre-law or second year pre-law. Otherwise, these law subjects will cast will be taught in first year for the 3-year LLB course, and third year for the 5-year LLB course. First 2 years of 5-year LLB course, that is pre-law, the students are taught social English and social sciences, namely history, economics, sociology, and political, 5 to 6 papers. So this is the position. Now, in first semester, there are 5 papers prescribed for study, namely contracts 1, family law 1, constitutional law 1, torts, and IPC. Here, contracts 1, contract subject is split into 2 papers. Contracts 1 in first semester, contracts 2 in second semester, comparatively easy. Then constitutional law, which was only one subject, one paper earlier, first chapter to last chapter, that is up to introduction to amendment, features of constitution to amendment of the constitution, last chapter was one paper. In the recent past, for Bar Council of India prescribed this constitutional law into 2 papers, constitutional law 1 and constitutional law 2, in first semester, second semester, respectively. And family law 1 and family law 2 were there from the beginning. Family law 1 may be Hindu law, Muslim law, bifurcation is there. Family law 1, marriage, divorce, adoption, maintenance, minority, guardianship, and succession for Hindus, Muslims, and other religions. And similarly, for Muslims, differently, Hindus, Hindu law means Hindus all one, Muslims means Muslims all concepts, including succession. Otherwise, marriage, divorce, adoption, maintenance, minority, guardianship, Hindus, Muslims, Christians, and all one paper. Succession, Hindus, Muslims, Christian, interstate, testamentary succession, extreme succession, and all for Muslim. That is one paper like that. For if you let me know through your comment the syllabus for family law 1 and family law 2. I will upload the lecture as per your syllabus, and I will give most important questions and tips. So these are all good information, good points for your information and follow-up action. Don't think that Rega Surya Rao takes a lot of time for introduction and he is boring and hammering like that. Please don't misunderstand me. And all these things are, if some all academic information is available in all books, this general information seeking your brightness of career will not be available in any book. That is why, like your teacher or your uncle and well-wisher, I am enlightening you on some other issues relating to your academic career. Now, in law of torts, in some universities only law of torts is prescribed for study, but in the recent past, 2 more enactments are added. Earlier, consumer protection was added for some time back, and subsequently, Motor Vehicles Act also is added to consumer law of torts. So now I have written book on law of torts, including Consumer Protection Act and Motor Vehicles Act. Consumer Protection Act, because Motor Vehicles Act, Workmen's Compensation Act, Carriers Act, so many acts are there. So many acts relating to civil wrongs are there. There are so many acts relating to regulation of civil wrongs committed by the individuals. They are also part and partial of the law of torts. But even though the law of torts is not codified, because there is no any one single enactment on law of torts stating that the law of torts act, the Indian Tort Act, like that. So they like Indian Penal Code 1860, the Indian Evidence Act 1872, like that. It is not there. So administrative law also is not codified, because administrative law, some legislations are taken. Some legislations are they are taken into the provisions in certain legislations are taken into account to deliver judgments in administrative law like Administrative Tribunal Act, Income Tax Act, Companies Act, like that. So many enactments are taken to deliver judgment issue to clear the issues in that subject. So in law of torts also, so many legislations are so many legislations are taken into account to deliver the judgments. That is why in that process to the nature of issues, nature of disputes in Consumer Protection Act and law of torts are identical. So to speed up the disposal of the cases, these special enactments are made. I told you about the importance of special enactments and special courts. The purpose of special enactments and special courts is to speed up the disposal of the pending cases and to decide the cases very quickly. In that process, Consumer Protection Act 1986, which is amended in 2019, a Consumer Protection Act, which is recodified in the year 2019, that is Consumer Protection Act 2019 is there. And the Motor Vehicles Act, which was originally passed in the year 1939 and which was recodified in the year 1988 and which has been amended with passing of the Indian Motor Vehicles Amendment Act 2019 that came into force on 1st September. That also is there. And ultimately, this Motor Vehicle Amendment Act 2019 also is being amended from time to time. So almost all enactments which were enacted during British regime or today in the recent past are being amended from time to time, taking into consideration the socio-economic changes. So now this Consumer Protection Act and Motor Vehicles Amendment Act are revised substantially. I will take up Motor Vehicles Act and Consumer Protection Act separately. I delivered lectures on Consumer Protection Act while delivering my lectures on arbitration, conciliation and alternative dispute resolution system, that is simply known as ADR. I have given good number of lectures on consumer protection, but the provisions and subject content is might be same with slight changes and change of sections. But the content is generally when a subject is when an enactment is decodified, recodified, reenacted, so old provisions, old material will continue in mostly with change of with some slide with necessary changes and revisions, but the subject as a overall would remain same in old enactment and new enactment, but some changes are there. Before recodification or be reenactment, we were speaking them, we learned them as amendment. After that, there is no need. Even if the act is amended, recodified again, subsequently amendments will follow. Follow. So that is why this Consumer Protection Act and Motor Vehicles Act I will take up separately with the latest development from internet as on today, dear friend. So in this class, I will let you know the most important questions from examination point of view on law of torts. As a matter of fact, from law of torts, first chapter to last chapter are very, very important and interesting. It is very difficult to say which chapter is more important, which chapter is less important. The examiner can give question on any topic or any question, but however, by virtue of my age, experience, and personal knowledge, out of these best among the best, which are likely to appear again and again, which are as a not only as a law student but as a member of public, as a member in the society, you are expected to know certain topics from torts or IPC, keeping in mind these two aspects, not only as a law graduate but also as a lawyer or a member of the public. you are supposed to know certain topic and which are repeatedly appear in examination. With this experience, I am placing before you most important questions. Since the volume of law of torts is huge, our student in the very beginning of his student career in legal studies may find it difficult to go through all the topics except in few institutions. Few students, brilliant students, and most of our law students are average students and above average students, below average students are there. Keeping the position of those such students in mind, I will tell you, I am telling you what are the most important questions from examination point of view. In first phase, you have to prepare six questions or six topics or six chapters and prepare a working notes. In second phase, you will have to concentrate five topics or five questions or five chapters from examination point of view. In third phase, you have to concentrate five topics, five questions, or five chapters from examination point of view. In fourth phase, you will have to face remaining topics. So, even if you are successful in first phase, you can confidently attend the examination. If you are successfully prepared the five more questions on this thing, you will be able to face the exam more confidently, and with third phase you will be able to face the exam most confidently, which I can tell you confidently. Dear student friends, let us know when once you want start preparation of your examination, I told you several times you have to choose the book which suitable to your standard and knowledge. How what is the volume of book you will be able to read, what is your memory power, what how depending upon your personal capacity, competence, standard, and patient hearing and learning, you choose a book. But you learn from which book is good. You learn from your teachers, you know from your two students, you know from your teachers and senior friends, and you go to bookshop, see some books on the same subject. You read out the contents in that book, which contents are easily understandable, which contents are suitable to your standard. You choose that book. It may be a 100 pages book or 1000 pages book, depending on your capacity. You select the latest book as far as possible, recently revised in that particular year. Still, for latest development, even the book is released on that particular year. For latest development, you have to refer internet and some articles with latest date. With the latest date. So articles and research paper published a few years back also will be there. Published recently will be there. Articles from civil services and other reputed institutions also will be there in that particular thing. So the articles and research papers published in the recent past, you have to take into account. If you want, you may ask for latest development touching the mic of Google. You will get the latest information. Now, I simply read out first phase six topic, second phase five topic, third phase five topics, five, five, six, 16 topics. There are more than 23 chapters in law of torts, in law of torts, but these 16 chapters I am enlightening. I will tell you to read in the first topic. Still, we have set aside some 9 chapters. No, now I give you, I read out the topics first, first phase, second phase, third phase, and then give you tips how to answer those particular questions. In first phase, you read no first before starting part chapter wise or topic wise, you read whatever book you purchased. You read from first page to last page or first chapter to last chapter. You give novel reading, or to know what chapter speaks about what. what is the defamation chapter, what is the content of negligence chapter, what is the contents of trespass, like that you give, then you will be able to know chapter wise. Secondly, then when once you have overall slight idea about all the chapters in the subject, you can pick out the most important chapter from examination point of view. While choosing this chapter or topic or question must be not only easy, interesting and less in volume, and most likely to appear in exam. While selecting the questions in order of preference, number one, you take the small topic, small, volume less, easy and interesting. Third, it is quite obviously appear in examination, and such factors you take into consideration. Further, as a student of law of torts, you are supposed to know some basic concepts of the topic, irrespective of their appearance in the examination, also have to be taken into consideration and then start preparation. So now in first phase, taught you, in addition to that, after giving novel reading, you have to prepare a notebook for each subject. You have to write a synopsis with topic wise side headings, meaning, definition, elements, cases, sections, if that subject sections is there, section, like that you have to maintain a working notes. And normal days you read the book as a read book, and before examination point of view, after giving just one novel reading of the book, various topic, and you repeat and by heart the side headings and points prepared in your working notes. So if you have to maintain some 50 pages to 80 pages working notes, 50 pages less than 100 pages working notes in a working notebook, you remember, you have to by heart side headings, and side headings cases you have to by heart. When once you are able to by heart side headings and cases, you will be, by giving the side headings and underlining the same, you will be able to write something. Whatever you write, you will get good marks, provided you maintain good handwriting. If your handwriting is not good, you will be helpless by birth, and you have to maintain good handwriting. If not possible, you have to maintain legibility or clarity of your writing, so as to enable the examiner what you have written in your examination. Even if you write wonderful information like general essay without any side headings or underline, the examiner will not be able to see what you have written. You have to actuate the examiner that what have you written, what best you have written. To draw the attention of the examiner, you have to maintain good number of side headings and underlines, so that the examiner will get good impression. When once you will be able to write first 2 3 questions excellently, the examiner will form a good impression on you and will start awarding marks liberally. Now coming to the point. These are all important things. 20 minutes above elapsed. Don't think that Dragarov is speaking something irrelevant. Everything is important for your examination point of view. Now you take out. First, I read out 6, 5, 5, 16 topics. Number one, tort, meaning, definition, nature and foundation of tortious liability, tort or torts. Second question, conditions of liability in tort are elements of tort, namely wrongful act, injuria, legal remedy. This is second topic. You concentrate it and make a working notes. Third topic, you have to concentrate defenses, because these three are will be repeated. Defenses will be repeated again and again in future chapters in other subjects also. Next, fourth one is remedies. Fifth one is strict liability. Sixth one is negligence. So in the first phase, you have to select 5 topics or 5 questions or 5 chapters. You have to make a working notes. By making the work notes, which area is asked more, you have to give top priority to that area. You present excessively, present clearly. Which area is not asked, you did not. For example, defamation, meaning, definition, elements, libel, slander, defenses. So in that area, you have to make a working notes. So which area is asked, that area you have to concentrate. And meaning definition you have to write commonly for anything. If you label why defamation definition elements are asked, you write defamation meaning definition elements, 3 elements you write. If they ask label and slender means, then you write meaning of definition, elements of definition, a label slender. Then you have to write about fully about label and slender. Suppose then you need not explain the elements of defamation. Suppose the privileges are asked. Privileges generally ask, defenses generally asked in short notes. Qualified privilege or absolute privilege, or truth or justification or fair comment, if they remember. So the question may be asked as essay question. If essay question is asked, you have to write more. If a short question is asked, you have to write more. So you first select how to answer this question. I will tell you topic wise. Tort meaning, definition, nature, foundation of tortious liability. That is tort or torts. Second, conditions of liability in tort or elements of tort. Tort, wrongful act, legal injuria, legal remedy. Second question. Third question, defenses, voluntary non-ficundiria, act of God, inevitable accident, etc. Fourth question, remedies. These remedies are, I said wrong in Telugu media from IPC defenses not. So the defenses in law of tort are almost common in law of contracts, because in law of contracts the remedy is civil remedy, torts remedy is civil remedy. So here and there, specific performance, restitution of property, damages, injunction, these type of remedies are there in remedy for breach of contract. This type of remedies are there in this thing. So when once you read all the remedies in contract, in torts, they will be repeated in torts. If you read in torts, they will be repeated in contracts also. They will be repeated again and again in future, so many subjects in entire career. So you better read all defenses in IPC. You better read all defenses in contracts, contracts for breach of contract. You better read all defenses in this thing. In IPC, in remedies, section 84, insanity asked as essay question. Right of private defense is asked as essay question. But in torts, this one, in torts, voluntary non-fit injury and rescue cases is asked as essay question. Others, act of God, inevitable accident, etc., may be asked as a short note. They will be repeated in future. There is, and generally defenses are there, specific defenses are there. For contract, for strict liability, defenses are different. For defamation, defenses are different. Nuisance, defenses are different. Trespass, defenses are different. Whatever defenses you studied in general defenses, they will be repeated in the specific defenses. Some defenses are for one specific tort. Some general defenses are there for one specific tort. So that is why I tell you, study all remedies and all defenses. 4 topics are over. Fifth one is, in every question paper almost there will be question on strict liability. Strict liability followed by absolute liability, and if strict liability is question, you shall write a little about absolute liability, and then you write a little about strict liability, no fault liability, which is taught elaborately in Motor Vehicles Act. Sixth question is negligence. Negligence is very big chapter. One main question and one short question is expected. Dear student friend, in first phase, you have to read, concentrate, meaning, definition, elements, and foundation. One question is the introduction question is expected, either foundation or meaning and nature. Second is early conditions of liability in tort. That is, injuria may be asked as short notes or fake question. Third one is defenses. Fourth one is remedies. Fifth one is strict liability. Sixth one is negligence. These six chapters you read well and prepare working notes. After having completed successfully these six questions and six topics, then you proceed to second phase, five questions. In that, the first topic is nervous shock. This is very small chapter. It is asked frequently in examination. Second one is defamation. It is not only important for examination. As an individual in the society, you hear the concept, the offense of defamation. People generally use about defamation case. That is why you have to know very well about defamation. Third one is nuisance. Nuisance also is commonly used in nuisance chapter, private nuisance, public nuisance. There is some most important case, Hollywood Silver Fox Private Farm Limited versus Emmet is the case. This case alone is asked, and you will be asked to expand the topic. Then you will have to write about nuisance. I gave lectures elaborately on nuisance. Next one, death in relation to tort. So actio personalis moritur cum persona, the quotation is asked and you may be asked the question. Suppose a defendant during liability, when the case is pending before the court and the case is decreed, defendant will have to face the liability. Meanwhile, without meeting the liability, if defendant dies, the case ends, no more liability according to actio personalis moritur cum persona. But that rule is no more a law at present, but the legalese also will be held liable for so far as civil liability is concerned. This topic I explained in detail. So, in second phase, fifth question is remoteness of damage. Whatever wrong you have committed, to that much only you are responsible for committing wrong. If person dies, he and resulting in the death of some more person, one cannot be held liable. Remoteness of damage. For example, a cyclist hits a pedestrian, he falls and receives injury. For that injury or fracture of leg, the cyclist can be held liable. But if the cyclist falls on another man, that man falls on, if the cyclist hits one pedestrian, that pedestrian falls on another man, that man falls on a boiling oil in a road-sided four-wheeler cart where some snacks are prepared with boiling oil. That boiling oil split out and damaged surrounding people and got injured the surrounding people, and in that process an accident took place, a person died. For all the consequences, that innocent cyclist cannot be held liable. To what extent he committed, for this purpose text of directness, text of forcibility is there. In this connection, repolymer's case is there, wagon mount case number 1, wagon mount case number 2 are there. Repolymer's case, wagon mount case number 1, wagon mount case number 2. These 5 topics you have to prepare. Their 5 topics are: number 1, nervous shock; number 2, defamation; number 3, nuisance; number 4, death in relation to tort; fifth one is remoteness of damage. These 5 topics you have to prepare. After completing second phase successfully, then you proceed to third phase. Then you have to read about trespass to person is a very big chapter. The trespass to person is there, trespass to movable property is there, trespass to immovable property is there. These topics are there. From trespass, one question is like, it's a big chapter. What to teach, what to study, what to read, I will let you know. Then second one is malicious prosecution. This is very small chapter like nervous shock. Malicious chapter question prosecution may be asked clear. Essay question are small. It is very bad. It is easy to concentrate, malicious prosecution, and false imprisonment are very small topics for preparation. They are also likely questions. Third one is vicarious liability. In legal theory and torts, I told you liability as a whole: independent liability, joint liability, several liability, constructive liability, vicarious liability, state liability, strict liability, absolute liability, no fault liability. These are the series of. As a law student, law graduate, advocate, you must know what is independent liability, what is joint liability, what is several liability, what is constructive liability, what is vicarious liability, what is vicarious liability of state, sovereign dichotomy, what is strict liability, what is absolute liability, what is no fault liability. These liabilities, the variation of the veracity of these liabilities, as a law student and advocate, you are supposed to know. But among all liabilities, strict liability is a question from strict liability very frequently asked. I told you, I put it in the first phase. And anything, the vicarious liability of master servant is there, lending of servant is a short notes topic, common employment is a short note topic is there, common employment short note topic is there. Next, in state liability, sovereign non-sovereign dichotomy is there, government liability, when government is liable, when government is not liable, that topic is there. Absolute liability, MC Mehta's Union of India case is there, MC Mehta's Union of India case. And discarding of defenses for undertaking dangerous and hazardous nature of manufacturing processes, and followed by no fault liability. All these things I explained in law of torts and legal theory and administrative law also. These aspects I discussed for your information. Next one is liability for animals or cinder rule. If a person's animals cause injury, a person may have dangerous animals, non-dangerous animals, dogs, etc. If a person's cow or buffalo or ox or cause loss or injury to other, it may be personal injury. These animal may knock somebody who visited his house, got injured, then he will have civil liability. Suppose his cows or buffaloes entered into neighbor's land and nibbled all the crop, then that owner, the owner of these animals will have to pay compensation to that owner of the land whose crop, the crop in whose land is spoiled, destroyed, like that. That is signed the rule. Occupier's liability is there. So in third phase, trespass to person, movable property, immovable property. In this trespass have been issued is there, leave and license is there for short notes. Six carpenter case is touched on that. And second one is malicious prosecution. Third one is vicarious liability, master servant liability, government liability, absolute liability is there. Next one is actual to no fault liability is there. Next fourth one is liability for animals or sign that is signed the rule. Fera nature, mensute nature, liability for dangerous animals of the owner of the dangerous animal, liability for owner of the non-dangerous animals like cow, buffalo, or non-dangerous animals, tiger, lion, etc. are dangerous animals. In states, we learn from sources that in Dubai, in some states and other countries, the people how our Indians maintain dogs. They feed the lions, tigers, and other dangerous animals also. These are the topics. So totally, I read out first phase taught meaning, definition, nature, and foundation. Second condition elements of taught, that is injuria. Third one, defenses, main in particular, voluntary non-fit injuria, remedies, remedies. Fifth one is strict liability. Sixth one is negligence chapter, first phase. Second phase, nervous shock, defamation, nuisance, death in relation to tort, remoteness of damage. These first five topics in second phase. In third phase, trespass, that is to person, movable property and immovable property. Secondly, malicious prosecution. Thirdly, vicarious liability, master servant, vicarious liability of state, that is state liability or government liability, that followed by absolute liability and no fault liability in brief. Fourth topic is liability for animals, that is center role. Law fifth topic is space liability. In first phase, 6 question, 6 topic. Second phase, 5 topic. Third phase, 5 topic. After completing these five, if you will be able to prepare more, you may prepare all the remaining topics. So now, then I give you the tips how to face the exam. Normally, any question paper on law of torts contains the for the first question would be from first chapter, that is define tort, distinguish it from tort, crime and other civil wrongs. That may be the question. If a question is asked like this, you have to write the meaning of tort in brief 4 lines. You have to give definition of Winfield and Salmond. Winfield definition, Salmond definition. Thirdly, after completing the definition of tort, yeah, and then you have to distinguish between tort and crime, tort and breach of contract, tort and breach of quasi contract, tort and breach of trust, like that. Sometimes they ask only define, distinguish tort and crime. When only tort and crime is asked, you have to draw a difference between tort and crime only enough. That's it. And this is a one-sided question. In other-sided way of questioning is the foundation of tortious liability. Discuss the foundation of tortious liability. The direct question is asked. Sometimes whether it's a law of tort or law of torts, discuss that question. The question may be asked like this. What is the explain in detail the foundation of tortious liability? Question may be asked like that. Question is that the physical tone theory may be guessed. There are certain number of torts wrong outside which the liability in the tort does not arise. The Fijian whole theory may be asked, asking you to whether it is a torts. Dear friend, it is not torts like student and students. Students singular, students plural. Girl singular, girls plural. Floral, book singular, books plural, like that. So taught, the nature of that word is, the significance of that word is entirely different. Taught is different, torts is different. The word taught is coined by Winfield, while the word torts is coined by Salmon. Tort refers to Winfield's theory on law of tort. Torts refers to Salmon's theory on law of torts. So I explained in detail about Winfield theory and torts mean if a particular wrong constitutes the elements of tort, remedy should be given. If that wrong doesn't have name previously, no remedy previously at that time, that new name is to be created, new remedy is to be provided, so that every aggrieved party for wrong or tort committed by other will get justification, that is advantage. Disadvantage is if we go on creating new names to torts and new remedies, the number of torts will be unlimited and subject will be confusion. That is Salmon's theory. Like a Fijian whole theory, every whole is one wrong tort, but some remedies are there, proper concerned remedies will be there. If any remedy is in consonance with any one of the tort, that Fijian whole theory, remedy is given, otherwise remedy is denied. But no new tort is created, new remedy is provided, so that the law of torts will be within a limited sphere and without any confusion. That is Salmon theory. For this, you may be required to ask foundation of law, tortious liability. Even then, you should write meaning and definition, meaning of tort and definition in 4-5 lines. Definition you have to write, there are several definition. You have to write Winfield definition and then Salmon definition. So if meaning definition elements is asked, meaning definition should be written. foundation of torts is asked, the meaning definition are to be written. For that purpose, you have to prepare meaning definition to tort, tort and distinction between crime and other, and then foundation of tortious liability. Like that, you have to prepare an essay or synopsis in a notebook. You have to repeat them. You will be able to answer very effectively. Then first question tips is over. And second question is conditions of liability in tort or element of tort. Every tort will have elements. First one is, I forgot to tell you, this subject like Indian Penal Code, part 1, but part 1, part 2 is not divided. This law of torts also can be divided into two parts: principles and defenses part 1, specific torts part 2. So principles means injuria is a principle, remoteness of damage it is a principle. Like that, there are so many principles are there, like tort. So wrongful act is a principle, remedy is a legal remedy is a principle. Like that, principles are there, specific is there. Specific for defamation is specific tort. For defamation itself, case can be filed. Negligence is a principle as well as a specific tort. Like a criminal conspiracy in the Indian Penal Code, the criminal conspiracy is treated as a principle, and criminal conspiracy is also treated as a specific offence under section 120A and punishable under 120B. It can be treated as specific. How criminal conspiracy is not only principle but also specific crime, but in law of torts, negligence is principle as well as specific. So to establish guilty of some specific tort, negligence is used as an instrument. For negligence itself, a suit can be filed. Then negligence is called specific tort. So like that, you have to, first question is over. Second question, three conditions of liability. You to identify a particular wrong as a tort, three conditions should be there. One is wrongful, second is injuria, third is legal remedy. So this injuria, damnum sine injuria, injuria sine damnum, how you study mens rea as the second element in Indian Penal Code, you study injuria as the second element in law of torts. So injuria sine damnum, damnum sine injuria are question or short question or main question are asked. First question is wrongful act, a simple point. Third one is legal remedy. Ibi remedia, ibi just, ibi remedia, ibi just, with reference to foundation of liability. If remedy is there, wrong is acknowledged. If remedy is not there, wrong is not acknowledged, then ibi just, ibi remedia, ibi just, ibi remedia is the topic. That relevance of motive and malice will come. Motive means good intention, malice means bad intention. If you do commit a wrong with good intention, still answerable, liable. If you commit a bad thing, if you commit a bad thing with bad intention, still one may not be liable. Suppose you cause harm to one person with a view to help another, still it is a wrong. So your help to somebody with your help to somebody will not be accepted when once you committed wrong to somebody. You will be answered for the wrong. Suppose thief steals and gives that money to poor, but stealing is a wrong. It is a theft. He is a thief. He is punished. So he committed theft for giving to poor people, cannot be accepted. So sometimes motive will not discharge a man from liability. Sometimes malice does not impute a liability, impose liability. For example, a man in Pickles' case, Pickles dig deep wells in his land with an intention to cause inconvenience to his neighbor. For the reason his land was not purchased. When I filed, because of the reason I did not purchase his land, he started digging deep wells so that I would not able to get water in my well. when case is filed, the court said he dug deep ditches in his own land. He exercised his own land. He might have committed that, he might have started digging deep wells with malicious intention. He cannot be held liable, is what the judgment was given in Pickle's case. So that's why in malevolence of motive and malice also you have to touch. So this injuria and motive are to be taken care of in second question. Third one is defenses. There are so many defenses to escape from tortious liability. Among them, there is a act of God is there, inevitable accident is there, voluntary non-fit injury or consent is there, is there, private private defense also is there. So many defenses are there. Inevitable accident is there, like that. So the defenses in law of torts and the defenses in breach of contract are almost common. So many common. The presentation is different. So in last class while teaching in Telugu media, I said the defense compared the defenses in criminal law, but they are not that much relevant. But some points are there. But here, breach of contract remedies, torts remedies are identical. You have to concentrate. Defenses you have to concentrate. Defense remedies also you have to compare with remedies. When plaintiff who suffered loss will file a case against the defendant for so many remedies, namely specific performance, damages, that is compensation, then injunction and other things. So expulsion of trespassers, like this. Fifth question, tort meaning, definition, nature, one question, or foundation of tortious liability may be there, second one. Second, injuria, damnum sine injuria, injuria sine damnum. Legal remedy point, relevancy of motive and malice you have to touch. Third question, defenses. What are the defenses in law of torts? And identically same defenses you find in breach of contract, law of contracts. But in while reading defenses, you read more voluntary non-fit injuria, rescue cases may be asked as a question, and others act of God, inevitable accident, and others may be asked as short notes. All these defenses will be repeated in specific torts like nuisance, negligence, strict liability, etc. There is no wrong to read all the defenses. Read all the remedies. So first, then defenses, remedies. Remedies, fourth question. Fifth, strict liability. Strict liability, actually liability starts from independent liability, joint liability and several liability, joint liability and constructive liability, vicarious liability, state liability, that is government liability, strict liability, absolute liability, no fault liability. This serial order you have to read. I taught this in law of torts. I taught this in legal theory also. So, but here, among all, strict liability or rule in reliance versus will question will come. If defendant is liable, if there is negligence in his part. If he is negligent, he is liable. If he is not negligent, not liable. But even though there is no negligence on his part, he is liable. That type of liability is created by Justice Blackburn in Rallens versus Fletcher. That liability is strict liability. This strict liability will have 5 defenses. By taking the help of 1 out of 5 defenses, the defendant can escape from liability. So, without negligence, liability without negligence is strict liability, but the strict liability will have 5 defenses to escape from liability. So, the defendant is not allowed to escape from liability. He must be held liable. All defenses are discarded. That liability is absolute liability, coined by Chief Justice Justice P.N. Bhagwati in M.C. Mehta vs. Union of India in 1960. This absolute liability is identical to no fault liability. This absolute liability is taught in torts for manufacturers negligence, manufacturer negligence for disposal of poisonous and noxious substances, resulting in death and inconvenience of the surrounding inhabitants of that particular area. This absolute liability was coined, but that similar liability in motor accident case is done. We call it as a no fault liability. This no fault liability was coined in 1980. 1980, Oriental Fire and General Insurance Company was Manjit Kaur. To that effect, the Motor Vehicles Act 1939 was amended and new section 92A and 92B were inserted, and subsequently the Motor Vehicles Act was recodified as the Motor Vehicle Act 1988, and this act again amended in 2019 as the Indian Motor Vehicles Amendment Act 2019. And even recently this also witnessed so many development. Recently in 2015, Motor Vehicle Act is again amended, imposing directing demolition of vehicles which are 15-year old to avoid to minimize the environmental pollution. So that is the strict liability. You have to meaning, facts of Raylan versus Fletcher's case, and defenses you have to write. That is strict liability, and also a few lines absolute liability, few small paragraph on state liability or no fault liability also. Next topic for discussion is sixth topic, negligence. Negligence is very big chapter. From negligence, meaning, definition, elements is there, and define negligence. What are the elements of negligence may be asked. What is the rule laid down in Donegal versus Stevenson case? Question may be asked. What is the principle laid down by Lord Dotkin in Donegal versus Stevenson case? What is the principle of neighborhood may be asked. For all these questions, you have to write. This question refers to negligence, elements of negligence. So, in Donegal versus Stevenson case, the principle of neighborhood is coined by Lord Dotkin. That in negligence, first topic is negligence, meaning, definition, elements. Then, if elements, so the conditions to be proved for negligence are there, but without proving conditions also man is liable. That is res ipsa loquitur. Burn versus Bodil. If the case simply asks Burn versus Bodil, this case refers to res ipsa loquitur. Res ipsa loquitur means the principle in negligence. For negligence, defendant is put to liability without proof of negligence. That is Burn versus. That is that. And defenses will be there. Those defenses are act of God, inevitable accident, which you studied in general defenses. And contributory negligence. Contributory negligence, first stage, both plaintiff, defendant liable. Second stage, whoever committed, who has lost negligence. That is second last opportunity rule. Who has avoided the accident, the opportunity. Plaintiff or defendant, who has that man is liable. That is apportionment of liability. The liability is distributed 50-50 or 1/3, 2/3 like that. And 100% liability. Even if no liability, then the no fault liability will come, coined in Manjit Kaur case. So these developments you have to write for this negligence. So from negligence, 100% there may be one question, and short notes on Burn versus Bodil or res ipsa loquitur may be asked, contributor negligence may be asked. So this is with reference to negligence. So after successfully completing 5 questions, preparing 5 answers in working notes, in a separate notes, then you proceed to second phase, nervous shock. Nervous shock generally asked as short notes or main question. You can write nervous shock in the sense without touching body, without any bodily contact, getting nervous shock. Suppose a motorist driving the vehicle violently and committed accident, or a vehicle, a four-wheeler or any vehicle in a public road, the speed limit is 20, but it is in running in excessive speed, creating fear in the mind of bystanders, and one weak bystander may get shock or collapsed or heart attack for which the driver of the vehicle is to be held liable. Earlier, such liability was not acknowledged or recognized, but in course of time, nervous shock liability for nervous shock was acknowledged in British case, in English cases, and subsequently it is available in India also, but such cases are not reported. Now coming to the next topic, defamation. In public, we come across the word defamation very frequently. That man wants to file defamation case. This man wants to file defamation. What is this defamation? This defamation, here are three segments. Three one. First one is defamation meaning definition elements. One. Kinds of defamation, libel and slander. Second, defenses of defamation, truth or justification, fair comment, privilege, in privilege, absolute privilege, qualified privilege, like that. So the question may be asked on defamation meaning definition element, or define defamation, what are the kinds of defamation, libel or slander. You can ask. Libel is actionable per se, slander is not actionable per se. Discuss. If question is there, you have to write about defamation refers to libel and slander. Libel and slander are the two kinds of defamation. You have to write the meaning and definition of defamation. Libel and slander meaning definition. Then you have to distinguish between libel and slander. Then answer ends. If defenses of defamation are asked, you have to write meaning, definition of defamation. Then you have to write three defenses. Then you mention three elements, only names, and then you write defenses, truth or justification, fair comment. Third one is privilege. This privilege meaning, and is privilege too can absolute privilege, qualified privilege. Like that, you have to write. You have to write. So in defamation also there are some developments. Then the defamation in India, libel is in India is treated as crime. It should not be treated as crime. It must be converted as a civil wrong. There is an argument, but this argument was not accepted. But still, libel or crimes, and the person who committed a libel is punishable under section 499 500 IPC. 499 500 499 libel defamation, 500 punishment for defamation. That is, next one is nuisance, private nuisance, public nuisance. For that, Hollywood Silver Fox Firm Limited versus Ahmed. That question is there. Next one is death in relation to tort, actio personalis mortem cum persona, remoteness of damage. In that series of consequences, repolymus case or wagon mode 1 or 2 will be given. If the cases are gas, it refers to right test of dire intent. This refers to forcibility. Like that you write. And third phase, trespass to person, assault, battery, mayhem, wrongful confinement, all false imprisonment. This in this false imprisonment or wrongful confinement is important. Immovable property means trespass ab initio. Trespass ab, suppose you occupy the neighbor's land. Our neighbor, we are in a house. Our next flat is empty. There is no house. We keep all nonsense in that. We keep our goods. It is trespass to land. If we put dust in that garbage in that land, spoil that land, it amounts to trespass to land. Like that. Trespass to movable property. So, misusing of the movable property of another by encroach of it through unauthorized encroach, it amounts to trespass to movable property. Like that. In trespass ab initio, leave and license are important for short notes. And now next one is malicious prosecution. If a person is unlawfully arrested and prosecuted, that is malicious prosecution. This is a very small topic. Essay question may be asked, and malicious prosecution and false imprisonment or wrongful confinement both are asked, and distinction may be asked between malicious prosecution and wrongful confinement. That is the topic is there. Next one is vicarious liability, master and liability. When master is liable, when master is not liable. If you read this well, this will be useful to you in Workmen's Compensation Act, labor laws. This will be useful This will useful that is master servant when master is liable for service. This is also useful for occupier's liability also. This can be done, and this master servant liability, if you read this, it will help you a little in vicarious liability unknown to criminal law. This will be partly useful to mens rea, doctrine of mens rea in criminal law also, like a master servant. In that, express landing of servant may be asked as short notes. Doctrine of common employment may be asked as short notes in vicarious liability. State liability is also very important. State liability, some seminars, when government is liable for wrongs committed by torts committed by servant, when government is not liable, when what is the uncertainty of law in this, and what do you mean by sovereign dichotomy. All these things I explained in detail about vicarious liability of state in law of torts and also in administrative law. Next, liability center role. If our dogs, animals cause loss or damage to our neighbors, what is our liability? That is center role. Dangerous animals, non-dangerous animals, how the owner is held liable if they cause injury or harm to others. Last one is occupier's liability. These topics you have to concentrate very well. In addition to that, still you have time. You should read the remaining topics if I left. So, dear student friends, you please concentrate on our law because I told you the greatness of our law course. And in this connection, I want to tell you one point. Suppose you are a practicing advocate. You have eligible for civil services and district judge exam. You possess some 7 years or other power standing. You have been selected for civil services IAS and district judge, additional district judge first. Because IAS has been acknowledged as the topmost position. Because many doctors in Maharashtra, some health university, out of 600 doctors, 108 doctors are selected for IAS one time, is what I found in Google. So how to how one has to struggle for MBBS seat? If not donation, capitation fee seat, how much? What is the position to get? How one has to struggle to get PG seat in medical? Or otherwise, how much he has to pay capitation fee? You know. How one has to struggle for IIT to get BITS Pilani seats, national IIM, Indian Institute of Management. So such students, MTech, IIT, very top courses students appear for IAS, and some will succeed, some will fail. When once they get selected for IAS, they will leave the MTech or MD or MS and are going for IAS. Basically, to get graduation level degree, they struggle like anything. And PG, they struggle like anything. In spite of all these, they get lot of opportunities in companies, lakhs, crores package. Leaving that, they go for IAS because of supremacy conferred on, greatness conferred on civil services exam. But big personalities or brilliant personalities are choosing IAS. At the same time, our law student, he may be a national law school student or he may be a small private college student with average knowledge. He may become degree, completed degree, 5 year course 22 years, 3 years course 23 years, thereafter 7 years even judge below 30 years. He will be both subject to his eligibility criteria by age eligibility criteria, eligible for civils and if he is selected as additional district judge, the powers of additional district judge and district judge are same. ADJ is competent to give death sentence to be confirmed by High Court. Still, when once an IAS selected candidate joins, suppose you are selected for both, you are selected for IAS and district judge, additional district judge. If you join as if you opt to choose IAS, your starting position will be assistant collector in collector office or sub collector in some subdivision. If you choose additional district judge, you will start your career as additional district judge in some district court. After some experience, you will be given the position of district session judge or principal district session judge. After some time, you may become High Court judge, Supreme Court judge, and so on. But these after then collector, collector, secretary, and so on. The maximum position of an IAS officer is the chief secretary in state level, cabinet secretary in central level. Still, he will be answerable and accountable to superior officers, chief minister or prime minister or central ministers like this. But the maximum position in this line legal field, your maximum position is Chief Justice of India. The Chief Justice of India is independently independent. He is not answerable to or accountable to anybody. He is privileged. He has an opportunity to conduct the swearing in ceremony of the sovereign of the state, President of India. So such a great privilege is conferred on our legal profession and legal studies. But when once you are privileged to enjoy such great privileges and significance, what is the responsibility as a last man you have to feel? The Bar Council is consistently pressing the centers of legal education to maintain 75%. How many students are attending? 75% attending. How many students are attending 5 classes directly, first period to fifth period? It depends upon your institution. Don't think that I am not criticizing. Your performance is not good. Your father, mother scold you. We find it in some movies also. If the hero is not serious about life and the parent consistently assaults the son. But not I don't do that much. I have no right. I cannot venture. I'm not dare enough to. But I can educate. I want to educate you like your well-wisher. That is why I'm telling these other things. Never think that they are nonsense. Never think that they are hammering. Never think that they are bore. For your well-being, like your senior friend, senior colleague, your well-wisher, I am telling you. Fortunately, our legal profession has been conferred supreme status by the supreme law of the land, that is the Constitution of India. Other privileges what a lawman enjoys as High Court judge or Supreme Court judge, I told you several times. Kindly give respect to our legal education, treat it as a god, work hard, do your best, discharge your responsibility, take a decent, handsome law degree, become great lawyer or great judge. This is my suggestion and message to you. I am doing my best, whether you make use of it or not, because during my lifetime I do it. If next generation want my lectures, I won't be available. Wish you all success. God bless you. Thanks for patient hearing. Thanks a lot.